Welcome to the Probate Nation. Whether you are caring for an elderly loved one as a court-appointed conservator or guardian, or as an agent named an advanced medical directive or financial power of attorney, or just helping out without any of those authorities, your primary goal in each instance is to provide your loved one with the best care possible as they age. Often that care involves paying for caregivers in their home, or it may involve paying for that care in an assisted living facility or nursing home. Getting good care for your loved one is important. Paying for it is often the challenge. If your loved one does not have long-term care insurance, and many folks do not, then you may have to seek assistance from the federal government program called Medicaid. There are many facets of Medicaid, and each state handles this federal program a bit differently. But I want to stress again that qualifying for Medicaid is not something you should undertake as a do-it-yourself project. Our show tonight continues the discussion on adult long-term care Medicaid in the District of Columbia. In this show, we will look at common misunderstandings, asset transfer restrictions, planning strategies for single people, planning strategies for a married person, and the application process itself. We are pleased to have returning as our guests two DC attorneys who handle long-term care Medicaid planning and application for the District of Columbia adults. They will serve as our guide as we continue the conversation about this long-term care financing option for all who may be traveling on the DC Living Probate train. Our first guest is a senior associate at the Elder and Disability Law Center in DC. She graduated from Boston College Law School in 2011 and clerked at the Massachusetts Superior Court for a year before joining EDLC. She's a certified dementia practitioner, and her law practice focuses on long-term care Medicaid planning and eligibility, life care planning and management, estate planning, and supplemental needs trust. Our second guest is the principal in the Landsman Law Group in Rockville, Maryland, where he focuses his practice on Medicaid planning and applications, guardianships, estate planning, and administration. He is a founding member and longtime board member of the National Academy of Elder Law Attorneys. He is rated AV by Martindale-Hubbell and has been honored in the elder law field as one of Maryland's super lawyers, Washington, D.C.'s best lawyers, and top lawyers by Washingtonian Magazine. Please welcome attorneys Abby Wolf and Ron Landsman. Well, again, all those qualifications, it's overwhelming. I feel dwarfed with all that great experience. Well, we're continuing our discussion about DC long-term care Medicaid. And Abby, let's take a look here and talk about, again, some of the common misunderstandings. What are some of those common misunderstandings folks have about Medicaid?
Sure. So I would say there's probably the top three. So number one is that you have to be completely poor to qualify. You can't have any money or any assets, and that's not true. Number two is the fear that Medicaid is going to take your house or take all your money. Medicaid doesn't take anything. Medicaid provides you with a benefit, and there are rules that have to be followed, but Medicaid doesn't come and take anything away from you. The only exception to that is after you've died. If there is a probate estate and you were on Medicaid, then Medicaid can come and recover after you're gone. And then the third is a lot of times people will confuse the gift tax exemption or the annual exclusion with an exemption for gifting for Medicaid purposes. So Medicaid has a 5-year look-back period. It counts any gift as a violation of that with limited exceptions. And the tax policy has nothing to do with Medicaid planning.
Okay. Now, I just want to follow up with one question there. Now, you said if you have a probate estate, that they can come back against that. So a lot of folks use revocable trust to hold their assets.
Yes.
Is that considered to be something that they can go against?
No, it is not. So in DC, if you do the proper planning and you are setting up your estate to avoid probate, then you can avoid that estate recovery.
Interesting. Well, that's good to know. Very good to know. Ron, what are some of the common problems that arise in qualifying for Medicaid?
The problems in qualifying.
Let's start with married couples, the common problem for married couples.
Well, for married couple, the big issue is figuring out what is called the resource allowance. How much is the spouse allowed to keep?
Okay.
And then the problem is making sure that you fit within that. But the fact is, DC is much more generous than people are aware, including a lot of lawyers. So that in fact the community spouse can keep virtually everything. if they structure it the right way and are willing to make some choices about how they deal with DC.
Okay.
So it's really an occasional mistake, which I've seen, which is where they get bad financial advice and they lock in income for the nursing home spouse. That's always that's just wasted money. But other than that, it's a matter of getting to someone who understands the rules and can make them work for them.
Okay. Okay. So let's turn to the 60-month transfer look-back rule. Transfers made in the 60 months prior to, I guess, applying, that they can cause disqualification. So please explain what we mean by that.
Sure. So Medicaid's looking at whether or not someone made a gift or an uncompensated transfer. And what they look at is, did you give something away and not get anything back? Or did you sell something for a lot less than it was actually worth? So for example, did you sell a $50,000 property to your kid for $10,000? They're going to count the difference in the value. If you did make a gift or uncompensated transfer, then Medicaid can penalize you. Even if you're otherwise eligible, meaning you've met all of the other criteria, they can say, well, we're going to impose a penalty period of ineligibility. And what that means is that they're not going to pay for your care for a period of time. And the larger the total amount of gifts that you've made, the longer the penalty period is going to be.
Wow.
Yeah, and there are some exemptions to this. DC, unfortunately, doesn't have a ton of clear-cut exemptions, but if you have a scenario where you can show that it was clearly a gift that was not made to qualify you for Medicaid, so you had a family member with a medical emergency or something like that, and you weren't intending to avoid paying for your own care, you can make an argument there. DC has something called a hardship allowance, where if you can show that you're in imminent danger of losing your own care, there's no way that you can get that money back. They may grant it, but it is tough. But if you also can have someone return the gift, so say you made a gift to your child and they're saying, Mom, I'll give you the money back, then that also can cure it and the gift won't be counted.
And then you can start with the normal planning process at that point to see how you make things work.
Exactly. And sometimes with our more complicated planning, we do use planned gifting, but it's part of a larger eligibility plan that has a lot of moving parts.
Okay. So I think that's really important about having the sort of the history of making gifts, okay, which we get a lot with the people who use powers of attorney. We want to make sure they have some of the history of that.
Exactly.
And it wasn't something that just happened because someone got that idea in their head. Well, Ron, are there approved, and we talked a little bit about this in the first show, but let's kind of go back again. Are there approved and tested techniques to remedy these mistakes that occurred during that 60-month look-back period?
Well, I want to actually go back and look at transfers more generally because, in fact, there are a lot of things that are permitted. Federal law is very clear about this, and although DC doesn't always easily comply, with a little push they will be. So you can always transfer something to your spouse and then get under that set, if you're married, get under that set of rules. If you have a disabled child, you can put any amount of assets, give them to a disabled child. You can give any amount of assets to a trust for any disabled person under age 65, your child or your grandchild or your great-niece. Those are probably the most important exempt transfers that have no dollar limit and no time limit. So you can do it after you're in the nursing home. You can transfer the money to your disabled child and qualify for Medicaid the very next month if you've completed it. Now the problem from many clients' point of view as well, I've got two kids, one's disabled, I really wanted both of them to get money. There are, either you have to accept the consequences that you can't have everything, but you can have a lot, and there are ways to get around that, depending on the family structure, the disabled child's issues and disabilities. Where there's no exempt transfers of the type that I just talked about, then Abby's referred to that, which is we in the business have a term for it, half a loaf or gift in return. You can literally give away, as a practical matter, you can protect at least half your resources, roughly, even if you're already in the nursing home, if you've got someone trustworthy that you want to park your money with. But as I tell my clients, you don't do this without adult supervision, because because if you do it the wrong way, you can get terrible results, and you have to start over. If you do it the right way the first time, then you can always protect half of your money or more.
So basically, you're reinforcing my concern about doing it yourself.
Absolutely.
Okay. And we want to reiterate that we're not encouraging folks just for the purpose of having you go see an attorney, but for the fact that there are missteps and potholes and unknown things that can occur that you wouldn't know to be watching out for, that experienced counsel can help you avoid. So again, we want to raise that level, and that's part of the reason why we do shows like this, is to bring that to people's attention. Well, let's talk a little bit about planning strategies for single people, Ron. So the threshold question, I think, for a single person, is there anyone they want to provide for that merits Medicaid planning being done? I think when we talked about this at the beginning of the show.
So in a sense, this show has already passed by the first question that we asked with the client, which is, why are you here? What do you want to achieve? If you say, I want to qualify for Medicaid, my question, it's not polite, but lawyers have to do it. Well, why do you think Medicaid will help you? Because it may be that what they really want is to have their resources used for themselves, and so you may use Medicaid right away, you may not. So that's really the first question, is what do they want to achieve, and then you sort of have to look at what their other goals are. Is there a spouse? Are there children? Are there other relatives that they want to provide for? And it's only in that context that you can really make sense of what the choices are.
Sure. And for a single person, those types of things that are available, if I want to protect some assets for somebody beyond the Medicaid eligibility itself, we talked a little bit about the fact that we can there's some things with housing ownership and stuff like that.
So you have a couple of actually, I'm glad you mentioned the house, because I want to warn you against one of the big mistakes people could make, which is just giving away a house. If you give away a house, you've committed a Medicaid and tax catastrophe all at the same time.
Not quite the trifecta, but it's close.
It's pretty close. So houses in particular. Now, to be sure, it was a bigger problem 10 years ago when houses were way up in value from 20 years earlier. Not so big now, but it's still an issue. So if I just give my house to my kid, and I think, oh, this is a smart move, I can get Medicaid in 5 years, and then the kid will sell the house. So first of all, I triggered the 5-year look back. I'm stuck with the 5-year rule. And secondly, when my kid sells the house, they're going to have to pay a lot more income tax than I would have had to pay. They can't take the exclusion because they didn't live in the house, and they don't get to use what's called stepped-up basis, which is if I let the house pass to my kid at the time of my death, it wipes out all the income tax liability up to that moment. Yes, so transferring a house is a choice, but one that has to be done. Now, there's a way to transfer the house. There's a form of a deed. It's I think for reasons I don't know why, it's called a ladybird deed, some reference to Lyndon Johnson's wife. It's a deed that passes title when you die, and that you own the house until the moment of your death. You're really the only one who can live there without permission. But when you die, it goes to your kid. That actually has a number of benefits from our point of view. First of all, the kid gets it with stepped-up basis, wipes out all the taxable gain. It's also immune to Medicaid estate recovery, because there's nothing in my probate estate when I die. At the moment of my death, it transfers. And if the value of the house is under roughly $500,000 or $600,000, depending on my age, I haven't given away the whole house. And so Medicaid counts the value of my gift as a lot less based on my age than if I had transferred the whole house. So if I've got cash and I can then cover the penalty period, I'm now delivering a house to my kid on much better terms. So that's for the single individual who's got a child or other relative they want to provide for. And the others that are really the one that from my practice, the one that people don't know about very much is the transfer to a trust for a disabled person under 65. So it could be a daughter-in-law or son-in-law who's ill. It could be a grandniece or a grandchild. That's a totally exempt transfer. And then depending on, although that trust has to be for that individual doesn't have to accept the trust. And so there are ways to manage the assets that actually benefit the whole family.
Interesting.
Yeah, so that's more complicated. It requires a competent adult beneficiary who has actual choices without any binding agreements beforehand, just straightforward transaction.
So those are the beginning of some nice little tools in the toolbox to begin to kind of save some assets, protect some assets, and
Right.
move some assets
That's
off the
right.
table.
And the key to these assets is to understand which tool to use. You know, you don't use a wrench to cut your quarter sawn
Right.
off, right? I mean, to make it a pretty extreme example. You have to know which one to use and to know their limits.
That's excellent. And again, I want to caution our viewers that Ron has gone in and mentioned some very sophisticated and maybe less sophisticated techniques, but they all have to be applied in an appropriate set of circumstances. And we want to come back and view those circumstances in the context of some real live fact situations that our colleagues will see on a regular basis, so we know how those might be best applied. Abby, let's turn to planning strategies for a married person. What are some of the common spend down strategies used for a married person?
Sure. So it comes down to what the goals of the couple are and what the needs of the community spouse are. One thing that we often use is a Medicaid compliant annuity, which
Okay.
is basically a very specific type of annuity with very specific rules relating to it, where we purchase a lump sum annuity for the community spouse, and it pays that community spouse a monthly income for the duration of the annuity. Again, there's a lot of rules there, so you got to make sure you're doing that properly. We also look at the house in that if there is a mortgage on the house or something needs to be done to the house, whether it's a repair that had been sitting for a while, or he or she just wants to update things, they can spend money on the house, which is an exempt asset. They can pay off any debts that they have. We also look to whether there is any disabled family member. So as Ron said, that still applies within a married couple case.
Okay.
We look to see if the couple needs a new car, something like that. And we always advise that they purchase pre-need funeral agreements. Someone's going to have to pay for your funeral at some point. So while it's an exempt asset, if there's money that needs to be spent, it's often a good idea to do that.
Okay, well, those are again, Dawson.
And I just actually, sorry, wanted
No,
to clarify
please.
one thing.
Yes.
So a lot of times we have people that think they have to start spending down, right away, but it's actually important that they wait until one of the spouses has been admitted to the nursing facility.
Well, that was interesting. That was my next question. When should
Okay.
these strategies be implemented? Because I'm thinking, well, folks might do like Rhonda suggested, start giving away stuff and start counting down the months on the calendar to 60 months has passed by.
Exactly.
So that was one of my next questions.
Yes.
Well, let's turn to the actual application process. We sort of get everything on the table correctly. The blocks are lined up in a proper order and so on. Abby, talk about what is actually involved with an application for a DC nursing home Medicaid coverage.
So the DC Medicaid application, there is an actual paper application where you're filling in the basic information about yourself and your spouse if you're married. You also have to supply verifications of everything that you're reporting. So they want to know your current assets. If you've made any gifts, you need to supply statements showing the gift and the value of it. You have to supply things like your health insurance, copies of your health insurance cards and things like that. But so the actual application itself is not overly complicated in DC. It's complicated when you actually have to submit it.
Okay. Well, let's talk. Oren, you want to
Well, I
add
was going
something?
to say, there's a big difference between a Medicaid application and a tax return. When you finish your tax return, you know how much you owe the government. When you finish a Medicaid application, you have no idea what's going to happen. Unless you have someone who's been through the drill and knows exactly what's being reported and what's going to happen, but it's not meant to tell you what the result is. It is simply an information gathering device by the Medicaid agency to decide whether or not they're going to give you benefits, and you need some expertise to understand what's going to work and what isn't.
Okay, and that's good to point out. Now, Abby, well, I know we've talked to other lawyers in the metro area, and so some places really advocate online applications versus paper applications. What do you recommend?
So DC doesn't actually have an online application at this time for long-term care.
They do not.
They do not. So you have a paper application that you complete, and then you have a question of how you're submitting the paper application, and that's where it gets tricky in DC.
Okay.
I love DC, I live in DC, but the Medicaid processing is a bit sticky right now in that there's no clear way to submit your application. The application itself gives you a few options to submit them. One is an email address that doesn't work. One is a fax that doesn't get checked. So we had always been FedExing ours in to get confirmation, but we found that they would get there, we'd get it signed for, and no one would process the application. So I've taken to emailing it directly to a Medicaid supervisor that I've developed a relationship with. The facilities are able to upload their applications directly in a computer system. So that's something when I have a facility that I have a good relationship with that I trust, I will still do everything myself, but I will give them the application to upload. I don't do this with all facilities though.
And you say facility, meaning a nursing home?
A nursing home, yes.
Okay, okay. Well, Ron, let's talk about some of the common red flags that show up. But I know you've kind of mentioned that over the course of a couple of our shows here. What are some of those common red flags that show up on a Medicaid application, which again, you're going to try to deal with before you submit the application? But
I guess the easiest one is something in a bank statement with a lot of zeros behind it. You know, unless it's an advance payment for income tax for $5,000 or $10,000, you know, Medicaid agencies will ask about that. And you know, when we do applications, we ask the clients to disclose. We then, my staff will look through all the financial records we get just to double check it to make sure. And if there's an explanation, we'll provide it. And if there's not, we'll find some way to work around it. I mean, we won't misrepresent, but we will advise the client what they can do to make the process less of a problem.
okay.
I think that's probably the number one issue to look out for.
Okay, okay. And Ron, what are the consequences? You do the application, you think it's all organized correctly, it looks good, you send it in, and they say no. What do we do?
You first of all trying to figure out why they said no.
Okay.
They may have said no for a good reason, and we obviously were surprised when that happens, or when a client comes in and we see what the reason is, and the question is how do we undo that or mitigate the effects? So it's a little bizarre little piece of Medicaid, but if you get turned down and you get turned down for a correct reason, if you correct that and reapply, there are ways to get Medicaid to pay for the period when you were not eligible. There's a couple law cases on it. I've worked on this issue. It's good at least for 6 months in DC of unpaid care. So certainly when you get a denial, the first thing you want to do is figure out what's going on. So even if it's correct, you can probably solve it and then start over.
Oh, interesting.
And then the other issue is whether it's not correct. Did they mistakenly include income that came out of the first as an asset? Did they misread a bank statement? Did they not believe or not get a record that a transfer was to a disabled person, to a trust for a disabled person? There are a lot of mistakes that get made. Sometimes they are just factual mistakes. They misread something. Sometimes it's a legal issue, and that's where we fought with DC pretty frequently on issues, and usually we're right. Will they? Whether someone over 64, for example, could put money into a pooled trust. DC for a while was saying no. They seem to have relented, and that's what the regulations say, and we normally get them to go along with that. So that's where you need to don't take no for an answer. There's always something to do.
Good. Now, I know we did talk about, and we've reiterated that we do not recommend, unless you have no assets whatsoever, that generally, we don't really recommend that you folks don't recommend that people take on in this application process as a pro se. Let's talk about nursing homes, though, real quickly, because I know, Abby, but You know, do you allow nursing homes to actually make Medicaid application for your clients?
So typically, no, that's the short answer.
Okay.
If I have someone that has no assets, they've actually just run out of money, there's no red flags, they didn't make any transfers, then a nursing home can handle that. But when you have anything that's somewhat complicated because there's a spouse, there are assets and you want to do planning, or maybe they did make a gift and it has to be fixed, that's usually outside of the scope of what a nursing home can handle. And depending on the nursing home, their staff is more or less trained in the Medicaid applications, but they're also not going to be looking out to protect money for the applicant's family. Nursing homes make more money on their private pay beds. So I would say, you know, if you're in a situation where you happen to be out of money, then that's usually fine. Nursing homes are great at a lot of things, but I just wouldn't trust them with doing a full Medicaid plan.
Okay.
I agree with that, but there's one thing that I have to say that we've all overlooked so far, which is in the married couple situation, there's ways to get the income of the nursing home spouse protected for the community spouse. And that's exactly the kind of thing the nursing home really could care less about, and yet there are plenty of ways to do that. And for the spouse who's got no resources to speak of, that income is crucial, and that's where handling the application, understanding what the potential is really important.
Well, I want to thank both of you again for coming back and sharing again in part two, you know, these further thoughts and insights and suggestions. Of course, great talent and a lot of experience here at the table, so really great help to the public. I want to thank you for taking the time to spend that with us.
Thank you.
Thanks for the opportunity.
You're very
Pleasure.
welcome. You're very welcome. You know, again, without a doubt, handling the finances for an aging adult can be challenging, and nothing can be more stressful than trying to figure out how to pay for their care needs, especially when your loved one has no long-term care insurance or has financial resources they want to preserve for their spouse or their children. DC Adult Long-Term Care Medicaid is a resource that may solve this need, but as we've learned during the course of Part 1 and Part 2 on this topic, there are income and asset qualification rules, transfer restrictions to navigate, and common pitfalls to avoid. But there are planning strategies for both single and married people seeking the Medicaid, and our guests touched on a few of those strategies. Those strategies and others will be examined in more detail in a series of future shows. But again, I repeat these words of caution. Whether you're trying to qualify your loved one for Medicaid coverage before a crisis presents itself or trying to qualify during a crisis, be forewarned that Medicaid planning, again, is not something that lends itself to do-it-yourself efforts, especially since mistakes leading to a denial of Medicaid coverage often are not curable for as long as 60 months. So again, I strongly encourage you to get advice from a qualified Medicaid attorney early if possible in your efforts to qualify your loved one for adult long-term care Medicaid. Early planning as opposed to crisis planning typically affords more planning options, especially when you're seeking to preserve assets for your community spouse or other loved ones. This brings us to the conclusion of our show tonight. We hope you found it helpful. Replays of this show and all the shows broadcast to date, along with other helpful information, can be viewed on the Probate Nation website. On behalf of the Probate Nation, thank you for visiting with us.